Good afternoon. It's great to see you all here. I'm delighted that there is so much interest in constitutional theory. And I'm here just to introduce the speakers. Once in a really, really long while, as a teacher of constitutional law, you all are students, and I'm a practitioner of constitutional law as well. Once in a really long while, you read something that makes you wonder if you've been doing it all wrong. And that is the effect that Richard Primus's book, The Oldest Constitutional Question, had on me. I'm really delighted to be hosting this conversation between Richard Primus and Noah Feldman. Richard Primus is the Theodore St. Antoine Collegiate Professor of Law at the University of Michigan Law School. He is a foremost constitutional scholar, very influential theorist of the Constitution, and he is also incredibly prolific. He is also a renowned teacher, having won the school's award for outstanding teaching on 4 separate occasions. And one interesting fun fact is that Richard Primus and Noah Feldman, who many of you are already familiar with, have been engaging in earnest with each other about constitutional theory since they were teenagers. So that's going on something like 35 years. So it is, I think, extra special for us to be here to engage with them in this iteration of this very long-running debate between them. So I'm delighted to have you here, and I give you Professor Primus and Professor Feldman.
Thank you, Professor Sook-Gerson. Thank you all for coming at your lunch hour to talk about constitutional law. As Professor Sook-Gerson just said, Richard and I met the first day of our freshman year of college. We started taking constitutional law together a year later in an undergraduate course when we were sophomores. And I would say by the end of the first day, I was hooked, and I think Richard was hooked maybe by the end of the first week. And I wish for all of you that you have in your lives interlocutors who are as generous, as brilliant, as thoughtful, as committed, and also as consistent as Professor Primus has been for me in all of those years. There's no one I'd rather talk about constitutional law with. There's no one else whom I run my ideas by, especially when I want to get them knocked down. And there's no one else whose work in the field of constitutional law in our generation is more profound and more significant. So we're really, really, really lucky to have Richard here. And we're going to do this conversationally. And I'm going to begin by asking you, Richard, to tell us at some modest lunch-like length what the central claim is of this amazing book.
Sure. So first, thank you both. Is this on? Yeah. Thank you both to you and to Professor Sook-Gerson for these over-the-top introductions. I want to also acknowledge the presence of Judy Marciano, who was my undergraduate tutor in Leverett House, who encouraged me to aim high at a time when that really mattered. Thank you. The book is about a core idea within American constitutional law, which is the idea of enumerated powers, right? You and I learned that idea very early in that semester in 1989. And it seemed to me when we learned it obviously correct, right? Article 1, Section 8 contains a long list of congressional powers. The dominant intuition is the list is there to limit what Congress can do, right? You write a long detailed list as an alternative to giving a general power. The fact that there is a list tells us that you're supposed to do only what's on the list. The list obviously can't cover everything, or why would they have written such a long list? And we learned, as generations before and since have learned, that this enumerated powers paradigm is core to the framers' design for how the Constitution should function, and that it is a critical piece of the architecture of federalism because it serves to limit the power of the federal government relative to the states. And various features of the constitutional text, including the fact of the list in Section 8, including the 10th Amendment, right, tell us that this is the way to do it. And as I say, this struck me as obviously correct when we learned it, and for many years after. And when I began teaching constitutional law at Michigan 24 years ago, that's how I taught my con law class. Right? That's how I taught that portion of my con law class. But over the course of several years, I came to be dissatisfied with the explanations that I was giving. I was saying things about the constitutional text and thinking that it's not quite right. I was saying things about the historical accounts that we give about where this came from and why, and thinking, yeah, that's not quite right either. I was thinking about federalism and the claims that this way of thinking makes about how federalism works, and thinking that's not quite right either. It is frequently the case that until you have to write something out at length, you don't really confront the problems that are in it. It's one of the problems with unsigned opinions. And I thought, maybe I'm going to pull on a thread here, I'm going to pull on a thread here, I'm going to see what's wrong with what's going on. And the more I pulled, the more other threads came loose until the entire garment unraveled. And I came to think, as I think now, that the dominant way that constitutional law regards enumerated powers is a lens on constitutional law. It's a lens that I'm going to call enumerationism. I can't claim credit for the term. I think the term is the invention of a man named David Schwartz, who teaches at Wisconsin. But enumerationism, it's not just one proposition. It's a bundle of related propositions and historical accounts and readings of texts that travel together, that together provide a lens through which we read the words of the Constitution, through which we disambiguate ambiguous historical episodes, through which we teach ourselves how federalism works. And the lens is off in a bunch of ways, right? Constitutional lawyers don't regard the enumerated powers paradigm as a lens through which we see the Constitution. We regard it as a basic fact about the Constitution, right? Like the document is written in English, right? Like if you read the Constitution on some other premise, you're just doing it wrong. But if you read the Constitution not to be within the enumerationist paradigm, you're not doing it wrong. I think you're recognizing that this is just one way to look at it and a flawed way to look at it for a bunch of reasons. And the reasons include that the text of the Constitution doesn't say what enumerationism teaches us to say. It can be read that way. There are lots of things about how we read the Constitution that aren't quite in the text of the Constitution. But it includes this stuff, right, for reasons that I'm happy to talk about in depth. The historical story that says the framers enumerated the powers of Congress in order to limit the reach of Congress is, I think, mostly wrong. It's not entirely wrong. There were people at the convention, I think, who thought about it that way, but there were a bunch of people who didn't. There were a bunch of people who thought the primary function of enumerating congressional powers was to empower the Congress against the state governments. If you're trying to get something powerful going against opposition in a world where there are already other power players, it's sometimes helpful to specify with particularity what their warrant is, right? And they were moving from a one-institution government to a three-institution government, which means that they had to specify who within that apparatus can exercise the powers. And a lot of Article 1, Section 8 is there, of this I'm quite confident, a lot of Article 1, Section 8 is there not to say it is the federal government, not the states, that will do this, but to say it is Congress and not the president who will do this. It's a separation of powers thing. One of the mistakes that modern constitutional lawyers make when they say, well, obviously the enumerated powers can't cover everything because then the enumeration isn't doing any work, is to fail to realize that limiting Congress is only one of the kinds of work it could be doing. It could be doing the work of empowering Congress, which it is. It could be doing the work of telling us what Congress and not the president should do, which it can, right? Those are functions. And in some respects, for me, most importantly, although I understand not for everybody, federalism doesn't work the way enumerationism tells us it works. Enumerationism tells us that this is the Constitution's primary technology for limiting Congress. The Constitution also has other technologies for limiting Congress, right? There are affirmative prohibitions like those in the Bill of Rights, and there are judicially created doctrines that limit federal governance and so on and so forth, right? And I think those are enormously important. But we are taught, those are auxiliary mechanisms. The chief constitutional mechanism, and certainly the one that the framers relied on, because they didn't have any of the amendments, was the enumeration of powers. And it's my view that the enumeration of powers is a wheel that turns no part of the mechanism of Federalist limitation. That's not what it does. That's not what it was written to do. And what we press it into service to try to limit Congress, and it functions very badly, because it's not well designed for that. Two sort of subsidiary thoughts here. One, the first thing we all learn about enumerated powers is the federal government is a government of enumerated powers, and that means that the powers of Congress must be limited in the aggregate, right? But the second thing we learn is it doesn't actually work that way, right? That for going on 100 years, it's been clear that Congress can legislate pretty much any regulatory project that it has the political will for, as long as it doesn't transgress affirmative constitutional prohibitions, because the enumerated powers are sufficient. The going intuition among many constitutional lawyers has been, we must be doing something wrong. It can't be the case that the enumerated powers are that expansive, or else why would they be enumerated? And what I want to say is, no, we haven't all been doing it wrong for 100 years. It's not the case that judges from appointed by presidents of both political parties for going on 100 years have been doing it all wrong. We've been doing it fine. The Constitution is built to enumerate powers of Congress that are sufficient to let Congress do all those things. What we've been doing wrong is talking about it the wrong way. We've been expecting the enumerated powers to do a thing that they were not built to do, and then we get disappointed and upset when they don't do them. In the chapter that's most frontally about the structure of federalism in the book, I end with an old joke that probably many of you know. Right? The joke goes like this. A police officer on night patrol finds a man stooped over under a lamppost looking at the ground. And the cop wants to be helpful, and he asks, did you lose something? And the man says, yeah, I lost my keys. I'm looking for my keys. So the cop bends over and looks on the ground, tries to help the guy find the keys, and looks for a minute and can't find anything. And asks finally, sir, where exactly were you standing when you noticed that your keys were missing? And the man points across the street. And the cop says, so why are we looking here? And the man says, well, it's dark across the street. Here, there's a lamppost. Right? I think Article 1, Section 8 is like the light of the lamppost. Because there is a long list of powers, it looks like the kind of place where you could go looking for something about congressional power, and since what you think you need to find is limits, you think you can find the limits there. It ain't there. That's not where it is in the mechanism. It's never worked that way. We should not expect it to work that way. That's the thrust of the book.
Before I ask my next question, it occurred to me that I should ask of the room. I recognize a lot of people from my class who I know are at least 2Ls. How many people in the room are 1Ls taking con law for the first time this semester? Very few. Okay, so I'm assuming that basically everybody in the room is 2L or a 3L or an LLM. Yes? Okay, good. That's good to know, because that means we're not blowing up we're not harming the naive infancy of the young by breaking the theory before they've been exposed to it. It also says what we can assume that people know,
yes.
So that's very helpful. Okay, so now I want to ask you, Richard, about the process of breaking an orthodoxy. And I have a few different questions about this, because this is as orthodox a belief as there could be in constitutional law. One way to do that is to go back historically, because this orthodoxy is framed, at least in part, as a historical claim. In fact, I would argue that it's framed almost entirely as a historical claim, because when you teach con law, if you teach the old story, the pre-Primus story, you still do teach that, at least by the time of the New Deal, the capacity of the federal government to regulate more or less whatever it wants emerged. So I want to go back to the history. And I specifically want to touch on something that you hinted at already, which is that, I think I'm paraphrasing you correctly, there were some people at the convention who did believe in enumerationism, even though there were others who didn't. So I guess I want to ask you to just hum a few bars of the historical story of A, how do you know that from the convention? And B, because I know it's going to come next, where's the smoking gun? Who's the bad guy? Who invented enumerationism and pulled the wool over all of our eyes? And I have a sinking suspicion that I know who the answer to that is, but I'll let you tell it.
Well, I have a guess as to your sinking suspicion.
This is what it means to talk about Cull, not with someone you've known for a long time.
Well, or you could just read Feldman. But yes. So I want to be careful here about the limits of my knowledge. Con law is rife with people who make confident claims about the 18th century. Con law is rife with people who make confident claims about what happened inside the Constitutional Convention. Con law, including the practices of both courts and tenured professors, are rife with people who cite Farron's records of the Federal Convention and say, so this is what happened, right, as if it's,
So that's what happened.
stenography,
Yeah.
right? It's not. There are days of the Constitutional Convention for which we have 5 pages of handwritten notes for 8 hours of conversation. There's just a ton we don't know, right? And I want to be careful always, and I try to in this book, not to overstep the bounds of what can be reasonably asserted about ideas at the convention. But I would say something like this. Most of the participants at the convention want a stronger general government. Right? General government is their term. They don't call it federal or national or central. The normal term is general government. Most of them
That's why they were there.
That's
Otherwise
why
they wouldn't have shown up.
Right. The project.
That's the magic of, if anyone's curious, that's the magic of the Constitutional Convention. That later it was called a miracle that they all agreed, almost unanimously. Because the minute they came out of the convention, half the country disagreed with them. And the reason that happened was that anyone who didn't want a bigger, stronger general government just didn't show up.
Or in a few cases showed up but left before it was done.
Yeah.
Because they saw which way it was going and didn't want to participate, right? There are a few people who stay to the end who drag their feet. But for the most part, right, as you say, right, that's who's in the room. Like, the problem they went to Philadelphia to solve was we don't have a sufficiently empowered general government. And so the project was make a stronger one, right? That's what they were doing, right? It's a pro-stronger government agenda. But they didn't all hold that idea with the same level of enthusiasm, right? I mean, no group of 35 to 50 people ever does. They didn't all have the same set of ideas about how to do it. They didn't all have the same set of ideas about what things needed to be protected against the interference of this stronger general government. And for many of them, opinions changed during the course of the summer, right? One seismic shift, just to give you a sense. George Mason, delegate from Virginia, is, during the ratification debates, one of the leading voices among the anti-federalists, right? Highly skeptical of the Constitution, highly skeptical of general power and so forth. He goes into the convention gung-ho about more general, he might even say national power, and says a lot of really interesting things early in the convention, as far as we can tell from the notes, about how that was going to work. There comes a point in the middle of the summer when he switches. In my own view, not original to me, but I think still not mainstream, that happened for him and for a couple of other Virginians when the deal to make the Senate 2 senators from each state went through. Because going in, they thought, well, we're the most populous state. Obviously, we're going to be the most powerful player. We like the idea of more general power because we're calling the shots. And then when they realized that they were going to be substantially disempowered, right, they slammed on the brakes a lot. Conversely, right, we all know that it's the New Jersey plan that is the less enthusiastic about federal power plan at the convention, right? They're the ones who don't like where this is heading in the beginning, where it's about more national power. Once this is a different conversation. It's called the Great Compromise. I think of it as the Great Extortion. Once the Great Extortion...
Those can both be true.
They can both be true. Once those things take place, and the tiniest states, New Jersey, Delaware, are going to have the same senatorial representation as Massachusetts and Virginia, the delegates from the smallest states start voting in favor of all more power to the national government, right? Because they have disproportionately large seats at the table now, right? So like even during the course of the summer, we realize their views about what should be national and what should be local are partly opportunistic, depending on where they're going to sit in that ecosystem, right? Rather than deeply principled or transcendent. And they're also evolving, right? The Constitution is not beta tested, right? Like a lot of it is, right, like catch as catch can. Okay. But I think we can say at any given point, right, there are some people at the convention, whether it's Luther Martin or the later Mason or sometimes sometimes people from Georgia, sometimes people from, like they're all over the map. Connecticut, Roger Sherman sometimes, right? Who do seem to have the idea that the enumerated powers are supposed to separate a federal sphere of responsibility from a state sphere of responsibility and can do that work. Like we can find voices like that. But as far as I can tell, they mostly get pushed aside, right? Like these are ideas that are articulated in the convention, but people stand up after that and say, yeah, that's just not gonna work. Like, it's not practical to enumerate all the powers that this Congress is going to need, and they give various reasons why they think it's not. And those calls for enumerated powers don't get picked up and turned into an enumeration, right? There's a complicated story, that I can tell if you think it's where we should take the conversation about how we get from there to the textual enumeration. But
I think you can skip over that.
Yeah, I think so too, right? Because where your question really goes is then why then did we start telling the story this way? And I think in large part it's an artifact of the discursive imperatives of ratification, and then the rise to power of the Jeffersonians in the 15 years after. So it goes something like this. The Constitution is put before the people for ratification. The opposition is going to come mostly from people who think this government is too strong. So as a rhetorical matter, the supporters of the Constitution need to try to say it's actually not going to be as strong as you think it is, right? There are people who read the Constitution during the ratification debates and say, hey, this Constitution gives Congress a general legislative power, right? That's what we read in this text. And the Federalists say, no, it doesn't do that, right? I think there are also Federalists who say, yeah, it does that, but they keep quiet because it's not helpful to make that argument at that point. They argue, no, the powers are enumerated. They especially argue it in response to the leading anti-federalist objection, which is, why does this thing have no Bill of Rights? And I don't know who makes the argument first. I can trace in the documentary record who makes it first, but I don't think that tells me who makes the argument first. The argument is quickly in play. Madison and Nathaniel Gorham of Massachusetts, who's a character I like a lot and is largely forgotten, make it in Congress very quickly. That we don't need a Bill of Rights because the enumerated powers will limit, right? That idea is a core part of enumerationism in the civic culture, right? A lot of you have probably learned this idea one way or another. I learned it first in high school and then again in college and then again in law school, right? But it was not an idea created at the convention. It was an idea retrofitted during the ratification debates when they came out and faced opposition that didn't like the Constitution because there was no Bill of Rights, and the Federalists had to huddle and say, wait, what are we going to tell them? There's no Bill of Rights. We have something to tell them. So they say this. But the first time Madison says this in Congress, Richard Henry Lee says, James, you got to be kidding me. Like, here are all the reasons why that is a terrible answer, right? The text of the Constitution already has affirmative prohibitions. These enumerated powers include a power to tax and a power to raise armies and a power to do all that's necessary and proper. That is plenty oppressive, right? Like, you can't tell me that this is going to prevent people from limiting other people's rights. Madison doesn't make the argument again for another 9 months, right? And then, right, and this is where your sneaking suspicion goes, but the argument is now in the ether, right? There are Federalists who make it, there are anti-Federalists who respond to it, and then it's part of the conversation. And so in the Washington administration, when there are people who oppose federal laws and need some sort of residual constitutional objection to oppose to it, this is ready to hand, right? The paper talks about, I mean, you know this material as well as anyone. The paper talks about Madison's opposition to the bank in the first Congress, right? Madison gives like a textbook paradigmatic enumerationist argument against the Bank of the United States and loses, right? I think that Madison had good faith reasons that he thought, in the way he understood constitutionalism, as constitutional reasons to oppose the bank. But they didn't include a clause that he could point to in the Constitution that said no corporations or no banks or something like that. So he made an enumerated powers objection, thus demonstrating, I'm not saying that it wouldn't have happened if Madison hadn't done that, right? Somebody else might have done it. Thus demonstrating the possibility of making that kind of an argument against a federal initiative that seems wrong to you when you don't have an actual text to stand on. And then the Jeffersonians, who like making arguments, pick it up, and it becomes an orthodoxy over the course of the first several decades of the 18th century. But it never is the way the government actually works. It becomes an orthodoxy in speech and not in practice.
So you're not an originalist, and I'm not an originalist. However, this is a book that will be of great interest and should be of great interest to originalists. And I can imagine an original public meaning originalist asking you the following question. And you can refuse to answer it, but that's not your style. The question would be something like this. At the ratifying conventions, which remember, from the standpoint of an original public meaning originalist, that's the whole ball of wax. It doesn't matter, this is what's sophisticated about public meaning originalism. It doesn't matter what they thought at the convention. It doesn't matter what they thought in their souls. All that matters is what would an ordinary ratifying voter at the ratification conventions, or maybe, there's a little ambiguity about this, someone voting in their state to choose the ratifying delegates, but we won't belabor the point. What would they have thought about enumerationism? Because from that standpoint, if you could tell me, well, actually this argument emerged in the ratification debates, and it's in enough of the ratification debates, as opposed to a year later, that it was in the ether then an original public meaning originalist might conclude that accepting your entire account as a matter of constitutional law, enumerationism is still binding on us.
Yes.
So just on the question of the ratification debates, not the debate in Congress about the Bill of Rights, by which time there's ratification, what answer would you give that person?
The answer that I would give is that what you are presenting as a historical account of meanings understood in the ratification debates is a just so story that doesn't survive historical scrutiny. And here's
Meaning
why.
that there was no such thing.
There was no, so the way the story is, there are sophisticated, as with any interpretive theory, and originalism isn't just an interpretive theory, it's a family of interpretive theories, right? There are sophisticated originalists, there are more and less sophisticated originalists.
Well, assume the most sophisticated originalist here.
So the most sophisticated originalists,
like the ones we have here.
The most sophisticated public meaning originalists, who are also enumerationists, would say something like this. What matters is, depending on exactly who, either what the ratifying public thought or what a reasonable member of the ratifying public would have thought, right? It could be real, it could be hypothetical. Okay. And I think, well, here's the problem. What makes you think that those people thought that the Constitution was enumerationist? And the answer that they give, right, you'll find this in Supreme Court opinions and in literature and so forth, is, well, here's what happened. The Anti-Federalists objected to the Constitution because it would make the general government too powerful. The Federalists responded by saying, what we're giving you is an enumerationist Constitution, right?
Already in the conventions.
Yeah, in the conventions, like a bunch of them say this, right? They don't, like it's not everybody, like
it's not the dominant argument, but it was an argument that was made,
Madison says it, Wilson says it, right? Like the leading members of the Federalist team, right, make this argument. And so the normal sophisticated originalist account says, that's a concession, or maybe a faithful representation, but it is the meaning of the Constitution as the ratifiers then understood it and relied upon in accepting the Constitution. And in a way, like the Federalists have to be held to their representation, right? They warranted this. People thought that that's what it meant when they ratified it. And I think, well, there are parts of this story for which there's evidence, and there are parts of the story for which there isn't evidence. What there's evidence for is that Federalists like Madison and Wilson and Iredell and others made this representation about the Constitution. But I can find no evidence of ratifiers saying or writing, you know, when I first saw this Constitution, I thought that it would make the government too powerful. But Madison has explained this enumeration thing to me, and I realize, right, that that's the right way to read it. That's what it means, right? I see no evidence of that. And I'm not surprised that I see no evidence of that, because I think that you'd have to be a pretty naive Virginia ratifier to think, well, I read this Constitution, and it looks like it creates a really powerful general government. James here, who wants a really powerful national government, reassures me that I'm reading it wrong. It's not what I say. And I'm going to go with that. I'm going to trust that. I don't know how he's going to enforce it. I don't see the evidence for it. What I see in the documentary record is there's disagreement at the beginning, and there's disagreement at the end.
So, but that almost proves too much, because that's a good argument, one I like, against original public meaning originalism, right? Namely, you think that the records of these ratification debates and the newspaper articles at the time can somehow give us what people thought, but actually people are sophisticated and there was rhetoric. But that's not going to satisfy the original public meaning originalist based on a lifetime of talking to such people, which is that, because then you're stuck altogether. And I will just say, Richard, to wear the hat of the originalist here, there's almost nothing in any of the ratification debates from any state where anyone ever says, you know, I was against this, but now I'm for it. It happens, but it's very, very, very rare. And so, also in a lot of these ratifying conventions, a lot of people voted against ratification. You know, we don't really know. It wasn't like they took a vote going in and a vote going out, like an Oxford Union debate. Like, we don't actually know who changed their mind.
That's right. We also don't know who voted for the convention in reliance on the idea that it did create a national government as powerful as the anti-federalists feared.
Agreed.
Right?
Agreed.
So you're asking really important questions. Let me say how I think about them. Okay.
Yeah.
To the extent that what I'm saying is original public meaning is not a good theory of constitutional interpretation, that's fine with me. Because what I'm saying is accurate as a matter of the historical record, and that's not my problem. That's the problem of someone who wants to do something with the historical record that can't be done with it. Right?
Like, it's not a fact that it can't be done with it.
No.
I've seen it done, you know? I mean, like, it is.
It depends what the it is. It depends what the it is. If what original public meaning, because, and here, like, there's a more sophisticated move that the original public meaning originalist can make, right? Some original public meaning originalists will say, no, Primus, you're reading it wrong. They actually did agree on this. They did rely on this, and so on and so forth. And I don't think the record supports that, and that's a disagreement that we can have about the record, where I'm pretty confident that I'm right. A more sophisticated public meaning originalist would say, see, I'm not looking for the actual subjective understandings of people at the convention, and I can count them up, and if 70% of them thought X, then that means the law is X. What I'm looking for is something more abstract. I'm looking for the right legal answer as it would have been understood at that time by a well-informed member of the legal community, right? Original public meaning, not understanding, but meaning, right? This is, and like the present cutting-edge generation of public meaning originalists would, I think, make this move. And I don't think that what you're doing, if that's what you're doing, is actually going to the past for authority. I think that exercise is trying to imagine yourself as the judge at the time and adjudicate contested questions based upon what you think would have made the most sense. And I think there are problems with anachronism there, and but like that is still available to them. What I don't, and then I will have an argument with them on the merits about why you think that's the best answer, right, at that time. But to the extent that the question you're asking, but at the point in your question where you say, I don't think that's going to convince a public meaning originalist, I'm going to say, the success condition for my work is not whether it convinces a public meaning originalist. Right?
I understand that.
Right? I do want to write a book that sophisticated, open-minded constitutional lawyers of many different points of view, interpretively and otherwise, will have to reckon with, and will have to say, you know, this gives me pause, even if it doesn't fully bring them over. I think that's worth doing. I think that's how knowledge and understanding advances. And to the extent that I've had people say to me, you know, Primus, you make a pretty good case about all these things, but I just can't agree with you that. And I think, okay, like we all have strong intuitions, not actually based ultimately on fact or reason, right? And you have some that don't let you come on board with this idea. I don't expect an academic book to bring you on further than that. But to the extent that what you think you're doing is giving me a faithful understanding of the history of the Constitution, I want to tell you you've got more trouble than you realize.
So now let me ask the question from the exact opposite point of view. This is the person who couldn't care less about original meaning, and in fact isn't that interested in history, and says, I'm sure that in this long book, I know Richard, whatever he said about history is definitely going to be faithful, and I'm willing to concede that he's right, that enumerationism wasn't really born in the context of the convention. It came out in the subsequent rhetorical debate, and is a bit of a swindle. But I don't care. I want to know the so what. If, as you've said, at least since the New Deal, and maybe before, we've never acted as though we really had enumerationism, because there's always a way for Congress to regulate anything. Even after Lopez, you could redraft the statute so that the gun that you're bringing onto the school zone has to have traveled, some part of it has to have traveled in interstate commerce, and it has. Then what's the non-historical takeaway? And I know it's significant for you because it's about, you mentioned the unraveling of the garment. There's a grander vision of what can come here.
So first, let's qualify in a couple of ways, right? It's not my position that on the best understanding of all of this, Congress could regulate anything it wanted to. Because we have a lot of constitutional prohibitions, and that's enormously important. Like Congress can't establish a religion. Congress can't eliminate the free press. Congress can't do all
whatever those mean, but yeah.
Well, yes, of course, but that would be true whether enumerationism were true or not, right? There is a rhetorical scare tactic that is part of enumerationism that says, well, if Congress could do that, it could do anything, which is supposed to conjure up images of, jackbooted thugs, executing congressional orders, right?
Who could imagine such a thing?
Well, I mean, again, the separation of powers thing is supposed to be doing some work. But it would be a lot less scary at most points in our history if they had said, Congress can do anything except this very, very long list of things that Congress cannot do, which cover the important rights that you are worried about, right? That's the first thing. The second thing is it's not my position that before the New Deal, Congress could do anything that was not affirmatively prohibited, right? I think the regime before the New Deal was one of implied powers. Congress could exercise its enumerated powers, and there was also a somewhat uncertain, but also somewhat specified basket of implied powers that Congress could exercise because it was the national government, or because of particular features of how the national government was.
Like the power to charter a national bank.
Like the power to charter a national bank, like foreign affairs powers, like the power to regulate the territories, like the power to create greenback currency. Like there are a bunch of powers that the Supreme Court acknowledges like this. Some of them are good and some of them are bad, right? But they're implied powers. What happened in the New Deal, I think, was this. The normal story is, before the New Deal, the system functioned the way enumerationism tells us it's supposed to function. In the New Deal, the court construed congressional power much more broadly, and now the enumeration doesn't do anything, right? It's true that in the era of the New Deal, the court started construing a bunch of the enumerated powers much more broadly, so much more so that pretty much everything can be brought within it, right? Some things are still blocked by the affirmative prohibitions. That's not a model of implied powers. I think of it as a model of cumulative coverage, right? You put these powers together and you get something that's wall-to-wall. Cumulative coverage put implied powers out of business because it made it superfluous. If Congress can legislate whatever it needs to legislate on the basis of an enumerated power, it never needs to go off menu and exercise an implied power, right? So we stopped thinking in terms of implied powers, and that made it easier for us to imagine that all there are is enumerated powers, right? Now, the person who asks, so what, it goes something like this. It's not that I think that all decision-making should be national. I like federalism. I like locally autonomous decision-making. I think the question of what should be done centrally and what should be done locally is an enormously important question. I think it is the oldest constitutional question. I think getting it right is really important, and I think some things about it is easy. I think some things about getting it right are easy, and many things about getting it right are hard, right? I just don't think the enumeration tells us what should be good locally, right? But as long as the enumerationist paradigm is dominant, as long as that's what we all learn when we learn con law, there are going to be lots of people who think if I am faithful to the Constitution, if I am faithful to the design of federalism, I must ensure that Congress does not exercise legislative powers that would be, the exercise of which would demonstrate that the enumeration is not limiting, right? This is what loses the case for the Solicitor General in Lopez, right? The court asks him, well, if Congress can do this, what can't Congress do within the enumerated powers? He can't answer, he's got to lose the case. This is what almost killed the Affordable Care Act. I mean, if this hadn't almost killed the Affordable Care Act, maybe something else would have. We don't know the counterfactual. But in the history we have, this is what almost killed the Affordable Care Act. Since I think that it's a fallacy to think the enumerated powers have to be limiting, I think that it would be, and since I think that governance is important and that it's hard to gin up the machinery of Congress to pass important legislation, I think it would be a real shame to strike down important legislation that we had gotten to the point of getting Congress to pass because constitutional lawyers are in the grips of the idea that they must force the enumerated powers to be limiting, and therefore this can't be. That strikes me as a real problem for democratic governance and as a self-inflicted wound. It's unnecessary. We don't have to do it. And as long as we tell the enumerationist story, right, it lies about, as Justice Jackson said in a different context, like a loaded weapon. When a case comes before the courts about some federal law that sticks in the craw of the judges, but they don't have a clause that tells them why, they may find a way, as I think happened in the case of the Affordable Care Act, to articulate an enumerated powers objection. And then what we'll get is a hodgepodge of disallowed statutes that don't coherently sort the national from the local in terms of what should be done where. They're just blows against democratically responsive governance. I think that we've worked out a pretty functional way of actually doing things, right? Congress points to enumerated powers and legislates, and what prevents Congress from legislating abusively, to the extent that anything does, is some combination of elections and affirmative limits, right? Those, I think, actually work pretty well for this sort of stuff. That is a long-standing and, I think, relatively healthy practice. And then we have a story, an official story, that tells us that something wrong is about the practice. And I don't want to sacrifice a healthy practice to a flawed story.
But that turns on a kind of policy claim that there's nothing valuable about the myth. You could imagine a story that says this myth of enumerationism functions the way a lot of myths do, as a kind of background check on our tendency to be absolutist. And it's therefore useful if you want to preserve the structure of federalism in all of its evolution and its complexity, for there to be a story that we almost never use in real life, according to which there are separate spheres. And those separate spheres are enshrined and codified in our Constitution. And therefore, we should be careful about Congress just arrogating for itself total authority to govern in all areas and in all respects. And if you say to me, well, that's unlikely to occur, I would just say, imagine a world with both houses of Congress controlled by the same party as the president, and imagine that it's not a party that would prefer to enact relatively little legislation, but a party that would like to enact a lot of legislation, and is empowered, among other things, by the observation that the current administration did pretty much whatever it wanted, and says, we're going to also do whatever we want to do with our majority, but it's going to go the other way. Mm-hmm. Maybe it's useful to have a myth out there that says, well, there's something that must remain exclusively in the hands of the states. And then when you say, but what is it? They can be like, well, it's basically like, it almost was, making people eat spinach, and for irrational reasons, it's violence against women. I mean, there's a whole explanation for why that could be the case, but it's still irrational. But we have the myth. And I'm speaking as someone who's more sympathetic to myths as valuable, maybe, than you are.
Yeah, so let me start with the biggest thing and work my way down. I'm not offering a constitutional theory that can save the system from rapacious bad actors in power. There is no constitutional theory that can do that.
Agreed.
Right, there isn't. Right? And you need people with a sense of public-mindedness and self-restraint in positions of power, or else there's no game to play. Coming to the smaller thing, I am not sure that you're more sympathetic to myth than I am. I think myth is enormously important. I said that I think enumerationism is a lens and a story that we tell. You can't do con law without stories and simplifications. You're going to use some set of stories and simplifications, right? But first, I think that it's really useful if we can understand the stories and simplifications as stories and simplifications, rather than thinking of them as brute true facts about the Constitution, in part because it will encourage the people who then act under the influence of those myths or with the guidance of those myths to do so a little bit more modestly, right? The consequence of my not behaving with this thing isn't that I am betraying the law. It's that I'm doing something that's in tension with the story, and I understand the point of the moral of the story, but I also think, like, is the story really enough here? Like, that's one set of possibilities. Another point I want to make is that the story that you just told about federalism didn't go through enumerated powers. I assume there are multiple stories that we could tell about federalism that wouldn't necessarily rely on the enumerated powers mechanism, right, as the way to do it. I think that your intuition here, Noah, which I think is a totally reasonable intuition, says we have this particular story that's part of our constitutional culture. Right? It's the story of enumerated powers limiting. And we have something that's desirable to protect, which is the idea of the value of local decision making. And so I see this and I see this and I think, well, maybe there's a supportive relationship between the two of them. Maybe this is helping that. And I think, you see, how would I know? How would we demonstrate that? That could be what that myth is doing. It could be. But maybe, like,
Can I try again with a better argument then? Because I buy what you're saying. I think you're right. And I also want to make sure I give a chance for people in the audience to ask questions. So I'll reform this as my last question, unless no one has anything to say, which is unlikely. Let me try to reframe it. Okay, this is not the same objection, but it's a cousin. If you think that our constitutional system has some common law-like features, namely that it builds on precedent, and you think that whatever they've gotten wrong in the past, there is this precedential basis, albeit one that doesn't have much bite, for the myth of enumerationism. And then you might look at this in a kind of Burkean small c conservative way, say, if Richard comes along and blows up a core lens on which we see the constitutional law, and we say, you know what, he's right, we're going to blow that up. Now we're opening the door to a lot of other blowing up of things, and those other blowings up are not going to involve doctrines that have only been used a few times at the margins. Those others, like, for example, the idea that the executive power is not far more extensive than was that of King George. And to be fair, there's some historical, Eric Nelson, here in the government department offers real historical evidence for the idea that at the convention, there were several people, some of them the same people as the anti-enumerationists, who exactly wanted the power of the president to be much more substantial than was that of King George III at that moment. But once you get that idea in, now we're in a game where constitutional law is much less respectful of precedent and is really just in the hands of whoever can tell the most compelling story. And then in those hands, we get radical changes and radical revision. So the argument would be something like, you're not doing any of that. In fact, you're saying we were wrong this whole time, but it didn't matter that much, except for our lens. But once we are willing to throw that out, we may actually have, that's the bathwater, but there might be some babies in it.
Yeah. So I think about this quite differently. I think that I've written a Burkean book. I think that what I'm saying, because the Burkean view, I think, would be, there's practice accumulated over time. It's unlikely that all the generations before us were doing it wrong. the moral of the enumerationist story is for 100 years, everyone's been kind of doing it wrong. And it is enumerationism, I think, that threatens, we lived for a while with a stable tension between an enumerationist story and a non-enumerationist practice. And if we were going to go forward into the future with that, I would say, fine. Like, you know, I don't need to mess with that. That seems fine to me. But in the last several decades, we've had the rise of a body of opinion and a body of power exercising opinion that wants to give enumerationism considerably more bite, right? In the hands of whom this thing will be used to strike down actual legislation that matters. And then the story and the practice are in conflict with each other. And we might have to choose one or the other. And at the moment that we have to choose one or the other, what I'm saying is, I don't want to sacrifice, I think it's a very Burkean thing, I don't want to sacrifice a healthy, stable, time-tested practice, you know, to reformers wielding a theoretical abstraction, right? That, I think, is the destabilizing thing. And to the extent that the worry is constitution, then other people can tell other stories and change constitutional law in another way, I would say, what do you think the last 250 years has been? The telling of the best story always eventually wins in constitutional law. The question is, are you going to take from that you're just going to wait until destabilizing forces come and tell stories about the executive power clause that are going to wreck this very nice precedent, stable constitutional government that we've had for a long time? Or are you going to say, no, actually, that story doesn't make sense, and this story doesn't make sense? And I'd like us to have stories that make a little more sense.
Okay, let me open it to the crowd.
Tell me your name.
Sorry, I'm Lila with Brielle, but have not taken any advanced constitutional law classes. So coming in with 1L con law knowledge. Okay. My question, I guess, when I was hearing you explain this idea and this doctrine, my initial sticking point was the 10th Amendment and talking about how, the powers not delegated to the federal government are left to the states. So how do you deal with that language talking about specifically delegated powers?
Great. Funny story. The book was published, someone posted something about it on social media, and someone posted, I can't believe this professor would write this whole book saying this. It's obviously wrong because of the 10th Amendment. And I looked at that and said, someone thinks I wrote 400 pages about this topic and never thought about the 10th Amendment, right? So, okay, because you're right. You should think of the 10th Amendment, right? But the 10th Amendment doesn't say what enumerationism takes it to say. Enumeration is a lens that causes us to read the 10th Amendment as if it said something that's not quite what it says, right? I happen to have the 10th Amendment with me. Here's what it says.
He always has the 10th Amendment with him. He also doesn't have to read it, but he's being modest.
The powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively, or to the people. There are multiple ways in which this text doesn't say what enumerationism normally thinks that it says, right? And I want to be a little forgiving about that, because there are many constitutional texts that prevailing doctrine reads as if they said something a little bit different from what they say, right? This is one of them, right? Here are some reasons why. First, and potentially most important, delegated and enumerated are different things, right? It doesn't say the power is not enumerated in the text of this Constitution. It says the power is not delegated to the United States. Every good lawyer knows that there are multiple mechanisms of delegation recognized as valid in the law. You can delegate in writing, you can delegate orally, you can delegate expressly or implicitly. Some delegations are inherent based upon the pre-existing background law of agency relations, right? There are a lot of ways to delegate. The idea that delegation here must mean textually enumerated is a gloss given by the enumerationist lens and not what it says here. And if you think this matters, or really whether you think this matters or not, the Congress that drafted the language knew that. We know they knew it because there were 2 attempts when the language was pending to insert the word expressly before the word delegated, which would have disambiguated the term. Then it would have been enumerationist. But Congress rejected those attempts, right? Congress didn't write the power is not delegated, comma, expressly, implicitly, or however, comma, right? That would have resolved the question in the other direction. But it's quite clear that they knowingly adopted language that would leave the possibility open, right? That's the first level. You want something a little more explosive, and then I'll shut up to let other people, because I could talk about this for a long time, but it's all in the book. There's a phrase in the 10th Amendment that we ignore. It's the one that says, nor prohibited by it to the states. If a power is prohibited by the Constitution to the states, it is not covered by the 10th Amendment, period, by the terms of the 10th Amendment. There are some things that the Constitution says states may not do X, Y, Z. Those things are therefore not covered by the 10th Amendment. Therefore, even if the 10th Amendment, where it applied, restricted the government to enumerated powers, it would have no application to those things. Those would be non-enumerated subjects of governance that maybe the federal government can do. So for these and other reasons, right, I think the 10th Amendment is entirely consistent with what I'm saying. Now, I also want to say this. As it is normal constitutional practice to staple ideas about constitutional governments to constitutional texts that say something in that neighborhood, right? We do this in a bunch of places. We staple the anti-commandeering rules to the 10th Amendment. I can't get there from the text of the 10th Amendment. But it's a logical place to file it because it's the closest we've got, right? I'm not opposed to that move in con law, but the text doesn't require that. That's a lens. Tell me your name.
John. My question is basically, if Congress has exhaustive legislative power, why wouldn't they include wording in the section 8, like the enumeration that says this enumeration is not exhaustive, this enumeration
Yeah.
is not a complete list?
Yeah. Excellent. Right? This is
/ expressio unius.
right.
Answer that too.
Like very reasonable question, right? So here's what I want to say. First of all, it's not my view that I know that Congress has exhaustive legislative powers. It's my view that it is not limited to its enumerated powers, right? There are third possibilities, right? More than is enumerated, but less than everything. Enumerationism often traffics in the rhetorical gambit of saying, well, if it's not enumerated, it must be police power, and it can't be police power, so it must be enumerated. That is a fallacy, right? There's a whole middle ground. Okay. It is not my view that the Constitution writers were committed to the creation of a Congress with general legislative power. If they were, they could have written, the Congress shall have general legislative power. If you want to know what that includes, here are a bunch of examples, but there's also other stuff, right? I don't think they were committed to that. Certainly, I don't think a consensus of them was committed to that. I think they were committed to Congress having enough power as they understood enough, right? And the enumeration of powers that they created was a bunch of the things that they thought were most important to specify. To rule in, right? To use an enumeration to rule things in is a lot more straightforward than to use it implicitly to rule out what isn't here, right? I think it might turn out that in ways foreseen and unforeseen, that the list that you write turns out to cover everything that comes up, right? Hundreds of years in the future, right? That's possible, right? But it's not that it was written to do that. It's just that there's no commitment in the Constitution that it be prevented from doing that. Whether it does that in the end or not is a contingent question, not committed to by the founders one way or the other.
Hi, my name is Arvind.
Thank you.
So Article 1, Clause 1 says all legislative vested in the Congress. And the 10th Amendment says powers not delegated. Do you think that when the 10th Amendment was drafted, they deliberately avoided saying powers not vested instead of saying powers delegated?
Interesting. No, I don't. First, Americans at the founding had more cavalier attitudes toward the precise wording of the Constitution than we usually believe. You read debates in the first Congress and you see assertions that people make about what the Constitution says. And over again, you want to say, yeah, it says something like that, but it doesn't actually say that, right? Including in these domains. The the strongest thing that enumerationists marshal about the vesting clause is the idea that the words herein granted indicate an enumerationist approach, right? Article 1, Section 1 begins, all legislative powers herein granted shall be vested in Congress of the United States. And constitutional theorists, like from Randy Barnett to Larry Lessig, right, have written, well, clearly, right, the Constitution is telling us it's not any legislative powers, it's only the ones herein granted, which they read to mean listed here. But this is a fallacy just like the 10th Amendment thing is a fallacy. It proceeds as if Article 1 said, only the legislative powers herein granted shall be vested in a Congress of the United States, which just isn't, I mean, in my copy of the Constitution, that's not what it says, right? It says all legislative powers herein granted. All men are mortal does not mean only men are mortal, right? This, I think, straightforwardly, what the text is saying is, if there are legislative powers granted here, Congress is where they go. It doesn't speak at all to the question of whether the list is exclusive. The fact that people accept the enumerationist reading of the vesting clause, like the fact that people accept the enumerationist reading of the 10th Amendment, like the fact that people accept the idea that the list tells us that the Constitution should be read to be enumerationist, is a function of bringing the enumerationist lens to bear. We think that's what the design was. We think that's what the history supports. Therefore, we read the text to support it in that way. And understanding that the text doesn't say that is a lot easier when you realize that all the rest of the parts of that frame don't do the things that we think they do.
You've just had an opportunity to hear one of the most brilliant exponents of constitutional law that there is, and I'm sure you appreciated it. I know I did. Richard, thank you so much for joining us.
Noah, you're very kind. Thank you all.